So let's kick off from the Minister of Justice, Paul Goldsmith.
Takutai Moana, Customary Marine Title Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the parliamentary website.
Mr. Speaker, I move that the Marine and Coastal Area Takutai Moana Customary Marine Title Amendment Bill be now read a first time. I nominate the Justice Committee to consider the bill. At the appropriate time, I intend to move that the bill be reported to the House by 5 December 2024, and that the committee have the authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day on which there has been a sitting of the House, on a Friday in a week in which there has been a sitting in the House, and outside the Wellington area, despite standing orders 193, 195 and 196. Mr. Speaker, in 2011, the Marine and Coastal Area Act established a regime for managing interests in the foreshore and seabed that carefully balanced the recognition of Māori groups' customary rights with the legitimate interests of all New Zealanders to walk, boat and fish our beautiful coastlines. As the Act's preamble records, up until that point, New Zealand had taken different approaches to managing those interests. Those approaches had ended up disappointing many. One way customary interests are recognised under the Act is through the award of Customary Marine Title. Customary Marine Title comes with valuable rights. These include the ownership of non-crown minerals, involvement in planning, and the ability to permit or decline certain resource consent applications, with some exceptions. CMT also provides holders with the right to be engaged with when new significant infrastructure is proposed. These rights were included in the 2011 legislation on the basis that the test for CMT was exacting, and recognising CMT only where customary interest had been maintained with sufficient strength right through to the present day. It's for that reason that this government believes that the Act was, and is, a strong affirmation of Parliament's role in achieving fairness for all, those who have interests in the foreshore and seabed. Along with holding the specified areas in accordance with Tikanga, Section 58 of the current Act states that applicant groups need to have had exclusive use and occupation from 1840 to the present day without any substantial interruption. This is evidently a high threshold. However, in making decisions on applications over the last 5 years, the courts have interpreted the test for customary marine title in ways that have diluted some of these strong requirements. The Court of Appeal, most recently, has interpreted the CMT test in a way that effectively did away with the exclusivity requirement, and the need for continuity, and significantly reduced the scope of what can constitute a substantial interruption. I respect the role of the courts as one decision maker under this regime and the challenges in interpreting the CMT test in the context of the wider Act. But for this regime to work as Parliament intended, the balance between the strength of the CMT test and the rights that go along with it need to be maintained. I note that the Crown has appealed the Court of Appeal decision to the Supreme Court. However, with many applications currently in progress, we can't afford to wait to address the Court of Appeal's error in its interpretation of the test. The purpose of these amendments is to restore the exacting nature of the test for CMT and to set aside the Court of Appeal and earlier High Court interpretations of the test that strayed from the meaning Parliament intended. The amendments provide significant clarity on how decision makers should implement the CMT test by expanding on the same test elements that were already in the Act. The amendments set the literal wording of the test above other framing sections of the Act, like the purpose and the Treaty of Waitangi sections. They further define what is meant by exclusive use and occupation, that it is both an intention and an ability to control an area to the exclusion of others. The amendments provide direction to decision makers on when they can draw inferences about the nature and extent of use and occupation. They clarify that any factual substantial interruption can interfere with CMT, not just legislative activities. They clarify that applicants are required to prove all the elements of the test, and clarify that the Act doesn't revive customary interests that were previously extinguished, with the exception of customary interests extinguished by the Foreshore and Seabed Act. Altogether, I consider this will reduce any ambiguity about the nature and strength of the test for customary marine title, and ensure that there is an enduring balance between the strictness of the test and the rights that go along with an award of CMT. The restored test will be applied to any applications that were still undecided at the time of my policy announcement on 25 July 2024. This retrospective application is necessary to prevent further cases from being decided under an interpretation that doesn't reflect the original intention of the Act. I recognise that this causes some difficulties for cases that are in the process of being decided, and that is why I have proposed this legislation be progressed as a matter of priority. These amendments will not affect cases that already have decisions, including those that are subject of appeals. I note the feedback I received from applicants and the report of the Waitangi Tribunal, but I stress that these changes are necessary and pressing. The Marine and Coastal Area Act sets up a very deliberate regime that strikes a delicate balance between interests. The sole purpose of these amendments is to ensure that balance continues to be struck and is an enduring one for Māori and for all New Zealanders.
The question.
Oh, there's a lot to unpack in that. Lot to unpack.
It feels like part of me thinking it's trying to circumvent the courts.
Yes, it is.
Oh, yeah.
I read up on the legislation and the results of the court procedures. Absolutely, what National's trying to do is legislate around the court, and basically return back the marine and coastal area Takutai Moana Customary Marine Title Amendment Bill. Jesus, these are big titles. Basically, they're trying to revert it back to how it was in 2011.
Because they can't come up with anything original.
Well, yeah, they haven't really. It's the frustrating thing about the 2011 Act is that it doesn't really. It lacks definition. So you've got courts who have to go, oh, okay, right, we're going to look at the treaty, we're going to look at te tiriti, we're going to look at how it needs to be interpreted. Then we've got to kind of balance it out with this act, and it's just like, it's a mess.
But I think that's actually kind of deliberate in a way, because when it comes to things like the courts, they need to have leeway to be able to interpret a whole bunch of things. It's one of the reasons why there are no written principles in the Waitangi Tribunal. Because it's done on a case-by-case basis based on whatever's going on. There's a whole bunch of different factors that come into it. When it comes to something like customary rights, it's the same kind of issue. There's never going to be a black and white, you had the rights continuously since 1840, which nobody has had because of everything that's happened since then. So there needs to be some leeway as well about, well, why don't you have the rights? What happened at this period in time, and giving the courts the ability to be able to judge things on a case-by-case basis. So by making sure that it's written down in black and white what the courts have to do and how they have to deal with it, it's very much stopping the courts from being able to go, well, what happened to you guys is different to what happened to these people and what happened to those people. And so we need to make decisions that are based on that, which is why it's a really interesting tool that the government's using to remove the ability to get those customary coastal rights from local tangata whenua. It's basically saying, if it's not in black and white the way we want it, then fuck you.
So I mean, I wrote a lot of commentary notes on this. Let's talk about the Customary Marine Title, because I don't think a lot of people know what that is. So the title recognises customary interests that iwi, hapu and whānau have had in the common marine and coastal areas since 1840. It's a title that can't be sold. And by the way, for all you Hobson Pledge guys out there, public access, fishing and other recreational activities in a customary marine title are unaffected. You hear me, guys? Unaffected. You too can go to the beach and get a damn ice cream and go fishing. No Māori is hiding behind the sand dune and is going to jump out and chase you down the beach with a taiaha. That is not happening. I'm not one of those Māori that are going to jump out from behind the sand dune with a taiaha and chase you down the beach. I might do it, though, if you act like a fucking idiot. But no, but
that's
no one is taking away your right to go to the beach. Yeah. So the other thing, too, is that it covers the area starting from the average high tide mark and ending 12 nautical miles, or about 22 kilometres out to sea. This does not include the seawater and river water itself. Okay? So you're not owning
so
the
you
water.
can't sit there and claim the water as your own. You can just claim, say...
You claim the land underneath the water.
In the water, such as the pippies.
Yeah. No one... No Māori people are coming out here and saying, we own the water. No, that's not happening. That's not in the legislation. No one owns the damn water.
Oh.